All rise. The Honorable Beatrice Lim presiding. Silence is hereby enjoined. Please sit down. Call the case for pretrial. Civil case number 1234454, Carlos Santos versus Janice Abad Santos for declaration of nullity of marriage. Appearances.
Good afternoon, Your Honor. I'm Attorney Neil Anthony Sorrentas representing the plaintiff, Mr. Carlos Santos.
Good afternoon. Where is the petitioner?
He's here, Your Honor.
How about the other party?
Good afternoon, Your Honor. I am Attorney Christopher Hapay representing the respondent, Ms. Janice Abad Santos.
Is the respondent present?
Yes, Your Honor.
All right. And for the state, who is representing?
Good afternoon, Your Honor. I am Attorney Carlo, representing the Office of the Solicitor General.
Good afternoon. Why are you interested in this case?
Because the case is controversial, Your Honor.
Okay, for today I will recognize the OSG. The lawyer from the OSG is appearing instead of the trial prosecutor. So this case is scheduled for pre-trial today. The case already underwent before the clerk of court, and we have the minutes of the preliminary conference. Do you have anything to add to what was taken up during the preliminary conference?
For the petitioner, Your Honor, none.
How about the stipulations? I see that the minutes of the preliminary conference did not enumerate any stipulation of facts. Just the general statement that the parties, guided by their pre-trial briefs, agreed upon the facts proposed by the petitioner in his pre-trial brief. The petitioner disagreed with the proposed stipulation of the respondent in her pre-trial brief. Is that it? Let us clarify this portion, okay? Next time, when you make the minutes of the preliminary conference, it should contain the stipulations, not just a reference to the pre-trial brief or other documents. Let us clarify from the respondent. Attorney Hapay, it is stated in the minutes that the respondent is admitting the proposed stipulation of facts of the petitioner. All of them?
Yes, Your Honor.
You are referring to item 3 of the petitioner's pre-trial brief, right?
Yes, Your Honor.
And all of these are admitted.
Yes, Your Honor. Item number 3 from paragraph 4 to paragraph 22.
Now, for the respondent's proposal of stipulation, the petitioner has not admitted or is not willing to admit any of the proposals for stipulations.
For the petitioner, Your Honor, the stipulation of facts stated in the pretrial brief of respondents are simply the issues of the case.
But these are not stipulation of facts. What you have here are not stipulation of facts. These are actually issues to be resolved during the trial, and naturally the petitioner is not expected to stipulate on these. Otherwise, that's it. Remember, when you make proposals for stipulations of facts, you are referring to facts. You want the other party to admit. Can you have a revised stipulation of facts on the respondent's side? What will be your proposal?
Your Honor, the respondent proposes to stipulate that she was without knowledge or information to formulate with regards to the paragraph 2.1 of the petitioner's petition.
So you want the petitioner to admit that. Attorney Sorrentas, you've heard the proposal for admission?
Admitted, Your Honor.
You're admitting that the respondent has no personal knowledge.
No, Your Honor.
That is what I am saying. And again, I remind you, lawyers, when you make your proposal, it must be something that you know the other party might not be able to admit or stipulate. Otherwise, it is useless. If you are on the petitioner's side, what will be the relevant matters pertaining to your defense, which might be admitted by the other party? The respondent is contesting the nullity, right? Why?
Your Honor, the respondent is contesting the nullity because she and the petitioner are not psychologically incapacitated.
Not psychologically incapacitated. You have that theory, your objective, and then from there, you break it down. This is your premise. This is your defense. This petition should be contested because neither of the parties parties are psychologically incapacitated. What is your support for that? What will be your supporting facts and evidence? You break it down and based on this, find these facts which might be stipulated upon by the other party. This is how you make your proposals for your stipulations. You have to make it subtle, meaning it should not be blatant. That for sure, they would use it to admit it for the other party. Like your proposal for the other parties are not psychologically incapacitated. Obviously, the petitioner will deny that because the petitioner precisely filed this case on the ground that both of them are psychologically incapacitated. So if this is your theory and your defense that you are not psychologically incapacitated, what will be your supporting facts and evidence regarding that? That's how you should get your stipulations. What are your proposal for stipulations again?
Your Honor, we propose to stipulate that the respondent had a constant communication with the petitioner, which was out of the country training at Stanford.
Admitted or denied?
The petitioner denies that, Your Honor.
Why is the petitioner denying that?
Because of the petition, the respondent, even when she is in the Philippines, the respondent failed to communicate or to answer the calls of the petitioner when the petitioner calls her.
Okay. What else? Any other proposal for stipulation?
Yes, the respondent proposes that she was able to provide support to her family also when she was training outside of the country.
Admitted or denied?
The petitioner denies the proposal for the stipulation, Your Honor.
Why?
In the petition, since the petitioner is the father, he already alleged that he provides for the family.
So there was absolutely no participation on the part of the respondent in providing support?
Yes, Your Honor.
Are you sure of that?
Yes, Your Honor.
Will you be able to prove that the upkeep and support of the family was shouldered by the petitioner alone with no participation on the part of the respondent?
Yes, Your Honor. The petitioner has the means because he is employed as the call center director.
Alright. Any other proposal for stipulation?
Yes, Your Honor, the respondent would like also to propose that during the time when she was in Cagayan, she had a constant communication with the petitioner.
Admitted or denied?
The petitioner denies the proposed stipulation because it is the attitude of the respondent that she will leave their house, their conjugal dwelling, and not to communicate with the husband or with the family when she is outside that area, Your Honor.
What else?
Your Honor, the respondent would like to propose that her training in Stanford was with the consent of the petitioner. That the petitioner gave his consent to the respondent in order for her to go to Stanford and conduct her training.
So the respondent's training in Stanford was with the consent of the petitioner?
Yes, Your Honor.
Admitted or denied?
The petitioner denies that, Your Honor. The respondent failed to get the permission of the petitioner for her study in Stanford.
So you mean to say that the respondent left for Stanford without prior consent of the petitioner?
Yes, Your Honor.
How was she able to leave without getting the consent of the petitioner? Was there really no consent given?
Although the petitioner knows that the respondent will be leaving for abroad, he has no idea that the respondent will study in Stanford.
So the petitioner is willing to admit that he knows that the petitioner was leaving for abroad, correct?
Yes, Your Honor.
What else? Any other proposal for stipulation?
Yes, Your Honor. In relation to the custody of Shiloh Santos, the respondent respectfully proposes that she earns $150,000 a month.
Admitted or denied?
The petitioner denies the stipulation because the respondent has no job or she has no means to get that earning, and while in school studying for the furtherance of her profession.
What else?
Also, Your Honor, the respondent wants to propose the fact that her work hours is from 8 a.m. to 5 p.m.
You think that the petitioner will be willing to admit that, given that earlier they already stated that they denied your proposal for stipulation regarding the $150,000 monthly income on the ground that apparently the respondent had no job. So if the petitioner's contention to the respondent had no job, You think that the petitioner will be willing to stipulate that the respondent's working hours are, as you said, 8 p.m. to 5 a.m.? Or do you want to withdraw that proposal?
Okay, Your Honor, we would like to withdraw the proposal.
Do you have any other proposal for stipulation? Earlier you said that you were admitting everything. The proposals for stipulation of the petitioner, all of the item 3, number 4 to 22. It also contains the fact of the marriage of the petitioner and that the petitioner and the respondent has a common child, Shiloh. And the custody is with the petitioner. We have no issue regarding the custody over the child.
We have, Your Honor.
What is your issue regarding that? You want custody to be transferred to the respondent.
Yes, Your Honor.
How about support? Who supports the child?
We also like to ask for a respective support from the petitioner.
But the child is with the petitioner. You mean to say, even if the child is with the petitioner, you are asking for support from the petitioner?
Yes, Your Honor.
Why? What will be your basis?
Well, because the petitioner is the father of Shiloh, and he always has the obligation to support the child.
But who is supporting the child now?
It is the petitioner, Your Honor.
The petitioner is the one supporting, and custody is also with the petitioner, correct? What will be your legal basis for asking for support for a child who is being supported and under the custody of the petitioner? There will be no basis for that. It will be different if, say, for example, the child is with you and you allege that the petitioner is not providing any support. But obviously, since the child is with the petitioner, that's not disputed that the present situation is that the child is in the custody of the petitioner. So obviously, the one supporting the child is the petitioner. So what will be your basis for the respondent's ask for support?
Okay, therefore, Your Honor, we would like to just withdraw the request for support only for the custody, Your Honor.
So with those additions, the other matters in the minutes of the preliminary conference are satisfactory to both the petitioner and the respondent?
Yes, Your
Yes,
Honor.
Your Honor.
How about the state, Mr. OSG?
Yes, Your Honor.
The state does not have any proposal for stipulation or any evidence to be presented,
None, Your Honor.
but you will choose to conduct cross-examination of the witnesses.
Yes, Your Honor.
Both the petitioners and the respondent's witnesses?
Yes, Your Honor.
All of the exhibits mentioned in the preliminary conference for both the petitioner and the respondent were already marked? Already here?
Yes, Your Honor.
Complete?
Yes, Your Honor.
Your Honor, with respect to the respondent, we would like to submit these two pieces of evidence which were previously provisionally marked during the preliminary conference.
What are these exhibits?
This would be exhibit number 5 that shows the completion certificate from the Cagayan Provincial Hospital, and exhibit number 9.
You're submitting the originals or certified copies only?
We are actually submitting the originals to the clerk of court, Your Honor.
Alright. Please have it noted. And you want a transfer of the markings on the photocopies to the originals?
Yes, Your Honor.
Alright. Kindly transfer the markings, Ms. Clerk of Court. Cancel the provisional markings on the photocopy and have it noted that it was transferred to the original. How about for the petitioner? All the exhibits are originals or certified copies?
Yes, Your Honor. All are originals.
No additional exhibits to be submitted today?
None, Your Honor.
How about the respondent?
None, Your Honor.
All of your exhibits were attached to judicial affidavits of your witnesses?
Yes, Your Honor.
Your Honor, with respect to the respondent, we will submit later on the attachment for the judicial affidavit.
But you were able to submit the judicial affidavits, right? Or not yet?
We were able to submit the judicial affidavits.
Okay, so this is exhibit 1 to 2. So you mean to say exhibit 3 to 11 were not attached to the judicial affidavit of Janice?
Yes, Your Honor.
Why not?
Your Honor, because of the technical difficulties in procuring the copies, we were not able to completely attach all the documents in the judicial affidavits.
But these exhibits were already marked, so you have them. It's just a matter of attaching them to the judicial affidavits.
Actually, we were not able to, we decided, Your Honor, to submit it once we have gotten all the evidence, such as these evidence that I have given to the clerk of court for markings today, Your Honor.
But today is already the pre-trial, so you should have at least made sure that during the pre-trial, these exhibits were already attached to the judicial affidavits. If you have a complete set, then you can attach it. Do you have a complete set?
Your Honor, we have the complete set with the clerk of court.
Attached to the judicial affidavits?
Not yet, Your Honor.
What can the petitioner say about this?
The petitioner would like to move that the evidence or exhibit mentioned in the petition, which are not attached in the judicial affidavits, must be impugned from the records of the court.
What will be your basis for that one?
Because under the judicial affidavit rule, it is stated that if the testimony of the witness refers to a document, he may attach that document as an exhibit, and if he wants to retain the original, he can.
So what is the effect if the exhibits are not attached to the judicial affidavit?
It will not form part of the judicial affidavit, Your Honor.
What is the reason again, Attorney Hapay, for failure to submit the attachments?
Your Honor, there was a delay in procuring the copies of these two exhibits that we have previously had the clerk of court marked. That is the reason of our delay for submitting the evidence, Your Honor.
Is that reason acceptable to the petitioner? Yes or no? Do you think it's a valid cause, Attorney Serentas?
For the petitioner, we will not willing to accept that, Your Honor.
So if it's not a valid cause. So
Yes.
if that happens to you, Attorney Serentas, you will not consider it as a valid cause.
Yes.
Your Honor, I would like to manifest something. I would like to manifest that early on, we have an agreement with the lawyers of the petitioner regarding our late submission of these particular exhibits to be attached to the judicial affidavits. And earlier, they assented to that request.
Do you confirm that? That there was a gentleman's agreement?
Before this court has come into session, Your Honor, the opposing counsel approached me that they cannot provide the documents because of some reason, and I told him that we will oppose his motion to accept those documents or reason, and he will be the one to explain to this court to give a valid reason of that one.
Do you recommend fine or should I ask the state? Let's just ask the state.
Recommending a 1,000 peso fine, Your Honor.
Okay, I am adapting the recommendation made by the OSG lawyer. So a fine of 1,000 will be imposed upon the respondent, and it will be paid at the same time the compliant judicial affidavit will be submitted. When will the judicial affidavit be submitted?
By Monday, Your Honor.
Through LBC?
Yes, Your Honor.
No other matters to be changed in the minutes of the preliminary conference? Petitioner, respondent?
None, Your Honor.
None, Your Honor.
Can we adapt the minutes of the preliminary conference with the notifications and clarifications made today for purposes of pre-trial?
Yes, Your Honor.
Can we now terminate the pre-trial? And let's just set the dates for the trial. The petitioner will be presented next week. Pre-trial is now terminated. Set this case for initial presentation of... Actually, can we just change the headings of this case? Instead of petitioner and respondent, let's change that to plaintiff and defendant to make it uniform. Carlos Santos will testify on November 16. Any other matters or manifestations from the councils?
None, Your
None,
Honor.
Your Honor.
Okay, pre-trial is now terminated.